business and human rights. And he thought a minute and said, oh, so people in business are supposed to be nice, good people? I said, well, hold it. And I started talking about the United Nations special person designated, John Ruggie. I have no earthly idea what you're talking about. And it's not to cast him in a bad light, it's that I think an awful lot of people probably haven't really made a connection between business, transnational business, and human rights. So I think this is a special opportunity to get up to speed on some cutting-edge issues. Now, Professor LaPlante will introduce Mr. Sherman, but I thought I'd say just a little word about her. Professor LaPlante, her bio is on page 8 of the program. She got her JD at New York University and then set out really on a life that has been characterized by deep and abiding commitment to human rights, including more than a half dozen years in Latin America, where she, amongst other things, served as a researcher with the Peruvian Truth and Reconciliation Commission and co-founded what's known as the Praxis Institute for Social Justice. She's taught at Marquette, University of Connecticut School of Law, and more recently has, of course, come on the faculty here at New England, where she teaches international law and a seminar on business and human rights, and she serves as director of our Center on International Law and Policy. So, Professor LaPlante.
Thank you. Good afternoon, everyone. So I was very excited to get the invitation to figure out a way to bring human rights into this conference because, as mentioned, it's often overlooked in business circles, although that's slowly changing or maybe even quickly changing, as we're about to hear. So I immediately recommended John Sherman because not only is he conveniently local, but he's a top expert in the field. And I first got to know him when I was interim director of the Dodd Center at UConn, right after these principles were approved by the Human Rights Council of the UN. And we had this amazing roundtable, Chatham rules, so it was kind of top secret conversation. And what was amazing is that at the table, we had academics, we had civil society, we had the State Department, we had business, we had everybody, all the stakeholders at the table talking about this new idea of business and human rights. I went on to join the faculty here, and fortunately we have the opportunity to expand on this work through the center, as well as teaching a course, and some of my students who are here present have been involved in that. But to introduce John Sherman in particular, what's amazing about his work is he came to it having years of practice actually working as general counsel with National Grid, where he had to not only worry about the ordinary types of legal issues, but also was involved with ethics and compliance and mediation, and we'll have an opportunity to learn more about that work. But he was invited to work with John Ruggie, who was a professor at Harvard, to work on these principles that the UN hoped to produce to start creating frameworks for actually figuring out how to hold businesses accountable for human rights violations, either contributing or causing. And he'll be speaking more about that in the work that he's done since then through his work as general counsel and senior advisor and secretary to SHIFT, which is basically a kind of think tank nonprofit that has resulted from many of the people working with John Ruggie to develop these principles and to go on to help to develop the instruments and the guidance, and he's currently working on that issue today. So I have a lot of more follow-up questions that I'm going to have for the Q&A and invite all of you to join in that conversation. And I'm going to turn the table over to you, John, to help people understand what we're talking about, business and human rights.
Thank you. Thanks, Lisa. I feel a little like I've worn brown shoes to a formal black shoe party here with everybody talking about the details of the sale of goods, and I have to tell you, folks, that I really know very little about the sale of goods. I know enough to kind of fool people at a cocktail party and be dangerous, so please indulge me. As Lisa said, I am a recovering corporate lawyer. And for the last decade, however, my specialty has been the field of business and human rights. And specifically, I've become interested in the role that lawyers, hard-nosed business lawyers, can play to help companies avoid stepping in human rights minefields, which they typically do. And lawyers, frankly, don't do a great job of advising their companies on that. The sale of goods by U.S. companies into foreign markets has very profound human rights implications for lawyers as well as businesses under something called the UN Guiding Principles on Business and Human Rights. Those guiding principles were unanimously endorsed by the UN Human Rights Council in 2011, and they have become the authoritative international standard on that subject, but more on that later. Just a couple of introductory bywords to supplement what Lisa said. I was for 30 years an inside counsel at National Grid, and its predecessor, many of you may know, New England Electric System. And I was, after I retired in 2008, I was privileged to join the core UN team that helped to shape and draft the guiding principles. And I now work for an independent, nonprofit organization called SHIFT. And we work with businesses, some of the top companies in the world that you've heard of, 50 or 60 of them. And we work with governments, we work with trade associations, we work with civil society to help them implement the guiding principles. So let me turn to today's topic. Now, the subject of human rights, people are very familiar with the issue of the human rights implications of global supply chains. And I put up on the board the impacts of the Rana Plaza tragedy in 2013 in Bangladesh, where over 1,000 workers who were assembling garments for Western buyers were killed when their unsafe building, which they'd been told to evacuate the day before, but the owner said no, just pancaked and collapsed on them, and created just a horrible situation, propelling many of the manufacturers to enter into various types of agreements to avoid these kinds of problems in Bangladesh. In contrast, the sale of goods receives much lesser attention, but they can also have profound human rights impacts, particularly where goods are misused beyond their intended purposes. Some examples are the Chinese government's use of internet surveillance technology to monitor and suppress the Falun Gong religious group, the Iranian government's use of cell phone monitoring technology to identify, arrest, imprison, and torture dissidents, the South African government's use of computer hardware to create electronic passports for the black population during apartheid in South Africa, the use by terrorists of the chemical fertilizer ammonium nitrate to create bombs, to blow up buildings, the use of computer chips, integrated circuits, and sensors by terrorists to make landmines, and the Syrian Air Force to make next-generation cluster bombs to be used against civilians, the use by child pornographers of encryption technology to protect the distribution of child pornography, and the use by security forces of cattle prods and narcoleptic drugs for torture in detainment centers. That's just That's to name a few. Now, this, of course, is not a law-free zone. There's lots of statutes in the U.S. and elsewhere that control the export of goods, particularly weaponry and military equipment. But you're going to have to go elsewhere to learn about those laws. I'm not going to talk about them. Instead, I'm going to focus on the challenge that businesses and their lawyers face where the law is an awful lot murkier. The risks are high, and this is the zone of soft law norms, whose violation can nevertheless have very hard consequences for companies. Now, to give you a sense of the issue, I want to talk about General Electric, which is the newest, biggest company to come to Boston. We're all very happy that Connecticut's loss is Boston's gain. But I've known GE for a while in this field, and I want to talk about their experience selling portable ultrasound in India. Now, around 15 or 20 years ago, GE's Health and Services unit developed a wonderful product, portable ultrasound. It allowed doctors to travel to remote areas in India, far away from hospitals, diagnose diseases, and save lives. It brought health care to millions of people. It was a good thing. And by 2006, GE had acquired a 55% market share. However, that same year, the Wall Street Journal reported in an article that in India, the ratio of female to male babies had dropped dramatically. And you can see that in the chart, and the reason was due to the use of these portable ultrasound machines. And it turns out that in India, male babies are highly preferred for both economic and cultural reasons. Women who were identified by ultrasound to have female fetuses were forced oftentimes by their families to submit to back alley abortions against their will with very severe health consequences. Now, the legal background is that since 1994, India had prohibited the use of ultrasound machines to detect the sex of a child, except in circumstances relating to sex-related diseases or disorders. 2004, the law was beefed up a bit, but the enforcement was really rather weak. So, all right, GE found this out. It's on the front page of the Wall Street Journal. What did it do? Well, it had a couple of choices. One choice was just to sit back and say, look, we don't have much legal responsibility other than to comply with the law, such as it is, and the product's out of our hands, and what people do with it, not our responsibility. But they knew that its reputation, its social license to operate were at risk, and that people were being harmed in an unforeseen way. So it decided deliberately to take a big picture approach. It developed strong internal safeguards, engaged proactively with key stakeholders in India, and attempted to change both the legal and cultural environment. And here are the steps that it took. It implemented an end-use policy prohibiting this use. It developed a training manual for all of its sales agents who were involved in the sale of these products, and told them that they had to escalate problems to management and not to sell if they sensed there was a problem without getting clearance from higher management first. It amended its sales contracts to add explicit warnings about the law and amended its dealerships agreements to do so, involving its lawyers. It met directly with its chief NGO critic, who was an Indian doctor, and submitted quarterly data and sales informations, a customer list to the government to provide a measure of transparency. It pushed for industry-wide action through a confederation of Indian industries, wanting to make sure that it could level the playing field with robust regulation, because that other 45% of its competitors, maybe they let GE do what it wanted, but just undercut them on price. And then it created a poster campaign to raise the awareness of the issue and the need to promote the status of women and girls in India. Now, all of this took place prior to the creation of the UN Guiding Principles, but this approach influenced the way and shaped the way in which the Guiding Principles ultimately took place. They took a big picture approach, trying to alter the environment, change the contract agreements that it could, and engage with the society. So with that build-up, let me turn to let me just turn first to, this is a very quick slide, I won't spend a lot of time on it, but you might ask, what is he talking about? What are human rights? Well, they have their source in international agreements, such as the UN Declaration of Human Rights in 1948. They have the two conventions that were that the UN enacted in the mid-60s. Human rights are aimed at securing the basic dignity and equality of all people. When they were first written, they were, in these international conventions, they were aimed at governments, not at businesses. But the research that Professor Ruggie did showed that businesses can affect every single one of them. Examples are of what businesses can do. Could be abuses of local communities by security contractors at mining sites, persecution of political dissidents through use of internet surveillance equipment, as I mentioned, and severe treatment of migrant workers in global supply chains. And this list of human rights can include such things as the right to life, the right to privacy, the right to be free from torture, the right to freedom of assembly, etc. This is not at all an exhaustive list. I'm not going to try to give it to you. So we turn to Professor John Ruggie, who is currently a head of the Corporate Responsibility Initiative at the Harvard Kennedy School. He had previously been, I think, the Chief Strategic Officer of the United Nations. Then he went back into academia, but always kept a handle in this. Now, the guiding principles are the product of 6 years of nearly 50 consultations with all kinds of groups, academics, trade associations, businesses, governments, lawyers, corporate lawyers, and I'll get to them. He was the author of the Guiding Principles, and he was appointed in 2005 by Kofi Annan in order to break a deadlock in the UN over this very subject, ultimately leading to the endorsement of the Guiding Principles by the UN Human Rights Council in 2011. Now, there are a number of firsts in that endorsement. It was the first guidance that the Council or its predecessor had issued on the obligations of states and businesses with respect to human rights. And it was the first time that that body had endorsed a normative text on a subject that they didn't negotiate themselves. And the endorsement was unanimous. Now, the guiding principles are based on 3 pillars. The first pillar, off to the left, is the state duty to protect human rights. And that's based on existing international law. And it requires states to protect against human rights abuses by business through appropriate law, investigation, and adjudication. The second pillar in the middle is the corporate responsibility to respect human rights. And that's a norm. It's a social norm which is based on minimum global expectations of businesses everywhere. It requires 3 things: that all businesses will adopt and respect a high-level policy commitment to respect human rights, It'll develop and implement a human rights due diligence process to enable it to identify and address its human rights risks, and to have processes in place to remedy human rights harm that they have caused or contributed to. Now, I should say that this second pillar is not a voluntary sign-up standard. It applies whether or not you as a company agree to it. More on that a little bit. I'll go to the third pillar on the right, the remedy pillar. That says that there is a need for greater access to remedy for human rights abuses in which businesses are involved. And it requires states to provide effective remedy, both judicial and non-judicial, for those who are injured. And it also expects that businesses themselves will establish or participate in effective operational level grievance mechanisms, which are low-level processes to identify and directly resolve problems before they grow. Now, going back to the middle pillar, the second pillar, the corporate responsibility to respect human rights does not impose new legal obligations on companies. We're not talking about binding legal obligations. But they don't exist in a law-free zone either. The laws of many countries already protect human rights in the field of privacy, discrimination, workplace, and public safety, labor and employment, to name just a few. In fact, compliance with the law is a bedrock requirement of the corporate responsibility to respect human rights. But local law may not always adequately protect human rights. In challenging contexts, they may not be enforced. They may not protect all human rights. And in some countries, they may even be in tension with human rights. And in those cases, the responsibility to respect human rights says that this responsibility exists over and above compliance with local law. It is not limited by local law. Talk a little bit about human rights due diligence. Under the guiding principles, which I mentioned before, that's part of the second pillar. A company is respected to respect human rights, both in its direct relationships, what it does in its factories and next to its communities, but also in its business relationships. And business relationships means all links in a company's supply chain, both suppliers and customers, and that's where we come to the sale of goods. And that means you have to undertake a four-step process of assessing the risk of involvement in human rights, taking appropriate action in response, tracking your performance, and communicating the risk as appropriate. And all of this is done from the perspective of the rights holder, from the person being involved, whose rights may be harmed. Now, where a company finds that it has caused, contributed, or been directly linked to harm, the guiding principles expect that they should take appropriate action. The action depends on the mode of involvement. I won't spend much time on this, but I'll come back to it if people want. And this is also a complex slide, and I won't go through it at all. But boiled down, it says that if a company contributes to harm along with a third party, be it a customer or a supplier, the company is supposed to then take action to prevent the harm, mitigate it, or provide remedy as appropriate. And if the company doesn't contribute or cause the harm, but its operations and services are nevertheless directly linked to the harm, it's expected to try to use its leverage or its influence to prevent or mitigate the harm. But it's not requested to provide a remedy. Now, the guiding principles have become a key center of convergence. Their uptake has been quite swift. and widespread compared to other complex areas like climate change. According to the UN High Commissioner for Human Rights, the guiding principles have become the global authoritative standard, providing a blueprint for the steps that all states and businesses should take to uphold human rights. They're increasingly reflected in law and in regulation, in public policy, in global industry-specific standards in the practice of companies, and in the advocacy of civil society. I've listed a number of examples here. They range from other multi-stakeholder standards like the OECD, multinational guidelines for business enterprises, the ISO 26000 standard, government policy and legislation in the United States, in Europe, and elsewhere, particularly dealing with disclosure of involvement in human rights harm in particularly problematic areas such as human trafficking and slavery. Many companies are adopting human rights policies and practices, and I can talk about that. Their adherence to the guiding principles is showing up in contracts and loan documents and company supply codes, and they have received the endorsement of the American Bar Association. I'll talk about that in a minute. Now, with respect to lawyers, Ruggie wrote that lawyers were among the most consequential new players that he brought into the business of human rights debate due to their access to and influence with the corporate C-suite. And acting on a pro bono basis, lawyers, including law firms and bar associations, notably the International Bar Association, played a major role in supporting its mandate. Now, the ABA formally endorsed the UN Guiding Principles in 2012, and the IBA, the International Bar Association, just published an extensive practical guide on the guiding principles for business lawyers, which, and I was proud to have chaired the working group that, okay, thanks. And I'll have the end of this slide. I have links for you if you're interested. Now, within the corporate bar, it's not so much law firms, and I think I kind of get the sense that most of the practicing lawyers are here from law firms or academia, but the key people who have taken this up are the general counsels of companies, because they're on the front line when it comes to fielding human rights decisions. And they've become, in the words of Ben Heinemann, who's the former general counsel of General Electric, they have become the go-to counselor for the CEO and the board on law, ethics, public policy, corporate citizenship, and country and geopolitical risk. And as a result, it's far more likely today than it was 10 years ago that if a human rights issue comes up, the first lawyer to get contacted will be an inside counsel. Now, as a result, a growing number of law firms have established business and human rights practice groups. There are a couple in the United States, Holy Hoag being one. They've had it for quite a while, but almost all of the major UK firms, and now they're no longer exclusively UK firms because they've all merged with US firms, or most of them have. They now have very active and large business and human rights practice groups. The US firms are, except for the ones that have a multinational practice, are now starting to getting into this area. Now, to the extent that the guiding principles are not incorporated or reflected in hard law, why should you as a lawyer be concerned about soft law? And this goes to the point, the conversation that Gary was having with his friend at breakfast this morning. You know, business is supposed to be nice. Now, one possible answer to this question It is a recent paper by the Harvard Law School Center on the Legal Profession called Lawyer as Professional and Lawyer as Citizen. And it suggests that lawyers can play at least 3 roles: technical expert, wise counselor, and leader. And a lawyer is clearly obliged to provide independent expert advice to clients on what the law is today. And you heard some of that excellent legal advice in the session before about what the UCC means. What does the International Convention on the Sale of Goods mean? How do you deal with it? And that's a critical part of legal practice. But when you put on your wise counselor hat as a lawyer, and in-house counsel are increasingly doing this, a lawyer has to be prepared to provide relevant context, not only to answer the question of what's legal today, but what may be legal tomorrow, and also what's right and fair in the context of the business's medium and short-term sustainability goals, to help the client decide, what do I do? And the answer isn't always just the law, and you walk away. Now, answering these questions requires consideration of a broad variety of contextual factors, in addition to what's technically legal. And they include institutional, political, economic, ethical, and geographical factors, including the global consensus on the guiding principles and their subsequent uptake. So given the shifting boundaries between hard and soft law over time, it's very difficult for a lawyer to advise only in the former and ignore the latter. So now let's turn specifically to the application of the guiding principles to the sale of goods. It can be challenging. The goal, as I said, is to avoid, mitigate, or remedy, as appropriate, the company's involvement in adverse human rights impacts from the sale of its products. The risks to the company of being involved can be quite significant. They can include legal liability, civil or criminal, relating to the allegations that the company was complicit in human rights abuse, even if the company didn't commit the abuse itself. They can include claims under laws that specifically prohibit misuse of goods, such as cybercrime or distribution of child pornography. And company executives have gone to jail. For example, a Dutch executive of a company was sentenced to 17 years in prison for selling chemicals to Iraq, which were used by Saddam Hussein at the time to suppress the Kurds. In addition, company involvement in human rights harm can include boycotts, divestments, negative press, brand erosion, lessened access to capital markets, reduced market capitalization, and loss of social, political, or legal license to operate. But I have to say at this point that the focus of the guiding principles is on harm to people, not harm to companies. It is not a cost-benefit exercise. However, experience has shown that the more severe the risk to people, when we're talking torture, we're talking rape, there is more risk to the company's bottom line. In the midterm, severe harm to people and harm to companies converge. Now, the approach under the guiding principles to involvement in human rights harm isn't the same as determining legal product liability for the sale of goods. As I remember from law school days, to prove legal liability, questions are, is the product defective in design or manufacturer, or did you fail as a seller to warn against non-obvious risks? However, under the guiding principles, to determine whether a company has responsibility to take action, the question is whether the use of the product to harm human rights was foreseeable. And if so, then a company has to take reasonable steps to address it. And this creates a number of challenges and opportunities for companies and the lawyers who advise them. There's a 2012 report from an outfit called the International Business and Human Rights Institute, which is a London-based think tank. And it lists the issues for companies under the guiding principles and how to address them. Here's what they suggest. First, use your, most companies have that sell or do business with customers or clients have some species of a know your customer process, and it's particularly apparent in the areas of anti-money laundering, bribery and corruption, exports, etc. Leverage those processes to include human rights issues more systematically. They do tend to turn up human rights issues, but kind of on a haphazard basis. Second, contractually exclude the certain use of products. Sales agreements that prohibit the customer from taking or providing services for any actions covered by international sanctions. Sales agreements that limit sales to certain types of buyers, such as professional users. Require compliance with seller codes of conduct that require respect for human rights. Use installment sales contracts and after-service sales agreements to provide some measure of leverage. And watch out for customer contracts that attempt to shift liability for involvement in human rights harm back to the seller, because that's inconsistent with the guiding principle. Now, of course, some of these steps may be possible, and some of them may not be, depending on the circumstances. In cases where it's hard to take these steps, it's useful for the company to consider a big picture approach, like GE did, as I explained earlier, in the ultrasound case. Ultrasound case by involving more players, lobbying governments, working with industry associations, working with customers and intermediaries to train end users, and working with other players to offer alternative, potentially less dangerous products to end users. So I'm going to leave you with some thoughts that the ABA had. I've given you quite a whirlwind tour of the UN Guiding Principles and their implications for the sale of goods. But the key takeaway that I'd like to give you is that as a practicing lawyer, you just simply cannot ignore critical, non-legal contextual issues such as the guiding principles when providing advice to your business clients. And here's what the ABA rule that it relied upon in endorsing the clients was ABA Model Rule of Professional Conduct 2.1, and I'm quoting from the commentary. Advice couched in narrow legal terms may be of little value to a client, especially when practical considerations such as costs or the effect on other people are predominant. Purely technical legal advice, therefore, can sometimes be inadequate. It's proper for a lawyer to refer to relevant moral and ethical considerations in giving advice. Although a lawyer is not a moral advisor as such, moral and ethical considerations impinge upon most legal questions and may decisively influence how the law will be applied. Now, I've included a slide. I've realized that you may not be familiar with this, so I've included on the slide. I'm sure Gary will distribute a list of readings if you want to dig deeper. I would be happy to answer any and all questions. So I thank you for your attention.
Thank you so much for your remarks. So I have a long list of questions that I'll save if there's no other questions from the audience. Are there any questions from the audience? Great.
So, can you give us a sense of how robust the willingness of corporations is to use these emerging business and human rights practice groups, and how robustly you believe they actually are committed to this process?
That's an excellent question. It's one that we continually monitor. Right now, according to Business and Human Rights Resource Center database, there are...
That's a UK group, right? Or is that not a UK group?
It's based in the UK, but it has offices in the United States and all over. It's basically a non-profit database that collects information about business and human rights. And it's used by the UN to store a lot of the information. There are about 370 companies worldwide that have publicly committed to respect human rights. And there's the 8,000 organizations that are UN Global Compact members that simply by virtue of joining the UN Global Compact have agreed to their 10 principles, 4 of which include human rights. We've gone deeper into that, but that doesn't answer the question, because your question is, well, how robustly are they doing it? You know, what are these processes? So we have created, we being a Shift and an Up and my organization and an international accountancy firm, Mazars, have created a UN Guiding Principles reporting framework, because one of the problems is trying to measure what companies are doing. So we are systematically going through actually what companies are reporting on human rights, not just their policy commitments, but the processes. And what we are finding, we've got companies like Apple and Walmart and GE and just about any of the big names that you can think of. And they're starting slowly to start revealing their processes. And we're starting to find good evidence of that. But I think that you're going to have to see the results of disclosure initiatives, the UK Modern Trafficking Act, the California Transparency and Supply Act, the Myanmar reporting regulations, the US Procurement Act, to start generating real information by companies who are going to have to disclose the processes, not just the policies that they have in place. But this was an issue 10 years ago, wasn't even on, you saw the words human rights and business, they weren't on the same page, let alone the same paragraph.
Would it be rude of me to ask one follow-on?
Sure.
So I haven't followed that so carefully, but has the corporate finance division at the SEC or anyone like that begun to require, as they did 5 years ago, if you have a cybersecurity problem, you have to disclose it? Have they, because that's where the real pressure for this would come, isn't it?
Yeah, this
where
is
it would have to be some kind of SEC or otherwise disclosure.
for U.S. companies.
Right.
If I'll just put aside what's going on in the U.S. If you shift to Europe, the EU Parliament has a couple of years ago issued a directive requiring big companies, I think there's about 6,000 of them, that are listed on the EU stock exchanges, basically to disclose their what they call non-financial performance, and by reference the UN Guiding Principles. They don't have to do it, but in Europe the approach is you either do it or explain why you didn't do it. Notwithstanding Brexit, the UK has adopted its own version of that, so that's going to continue. In the US, you have organizations like SASB, which is the sustainability something or other. It's a group that is pushing for more disclosure of ESG, environmental, social, and governance. And this is on their agenda as well. No, the U.S. Regulatory authorities at the SEC are still messing around with this.
Yes. Okay, good. I actually had a question about the role that labor law and labor unions play in making sure that companies to adhere to some of these principles. And just a recent example came to mind. We had the Verizon strike. And so one of the complaints had been that jobs were being sent overseas, and then those workers overseas were going to be receiving very low wages. And so I wonder if we have some existing legal mechanisms already in place that, if strengthened, could help to address some of these issues.
Well, what if I go back to the slide? One of the human rights issues, one of the human rights is the right to freedom of assembly. I can't quite identify it in this group here, but to try to answer your question in a big way, one of the impacts of globalization has been the migration of jobs where there is greater regulatory protection to areas where there is lesser protection. And you saw it in Bangladesh. Unions are not encouraged. You see it in China, where there is no real unionization, but basically a government. And I think that one of the reasons why the right to freedom of association is so important is that in a country, it prevents this race to the bottom, which is really what one of the side effects of globalization. And I'm not going to get into that debate, whether it's a good thing or a bad thing. But I think one of the things in the guiding principles was that basically there is something called the International Labor Organization. That is a part of the the UN. It's been around for quite a long time. And the guiding principles pretty much left their structure intact, endorsed it, but basically tried to deal with other issues. So the answer to your question is, yeah, of course, it's really maintaining the right of workers, both here and abroad, is part of respecting human rights.
One question I had is whether or not pricing plays into this, and in particular, you use the pharmaceutical industry with pricing of life-saving drugs in Africa. But where does that play into how businesses should consider this?
Yeah, well, there is, of course, the right to life. There's also a right to adequate medical care. These are rights that need to be protected, and it has been a very major issue in developing countries. Is the right of access to life-saving drugs. It's been a huge issue in Africa with respect to AIDS, as well as in India. And there have been a lot of pitched battles between pharmaceutical companies and governments about the need to make these drugs more available. They have been fought out in the courts in those areas. And here you have a clash between the state duty to protect human rights and the business responsibility to respect human rights. And yeah, I think it's a question that is it's complex because pharmaceutical companies are entitled to a return that includes the expense that they take to identify and develop drugs. But it is a legitimate business and human rights issue, and I think it's become one that has become identified in the U.S. Very recently when you see what's happened to the price of EpiPens. And I've been thinking about that from a human rights perspective. I mean, just because you can exploit a market, a window in a market, does that mean that you should? Do you have a fiduciary responsibility to your shareholders to do so? Well, I'm not convinced that argument is a good one. But that one's playing out in the U.S. But yeah, it definitely is an issue.
So we are at the end of time. Do we have time for one more question?
Take a couple.
Okay.
So go ahead, I know you have questions.
No, I actually am different. That was if there were no questions in the
I
audience, so
just
go
had,
ahead.
maybe too
Yeah.
vague of a question, but to what extent do the U.S. courts have jurisdiction over behavior by or conduct outside the U.S. that might lead to human rights violations and human rights liability in various states?
Sure, well, that question invokes the Alien Tort Statute, which had been used for many, many years by foreign victims of human rights abuse to bring suit in the United States. In the United States courts, this is an ancient statute that was passed during Jeffersonian days dealing with pirates. And it was very much narrowed in 2013 by the U.S. Supreme Court in the Kyobo case, basically saying that narrowing it to make sure that such statutes, that statute can only apply where the plaintiff and the defendant and the action somehow touched the United States. So something that was foreign acute, something completely outside of the United States, wasn't subject to its jurisdiction. So that statute is very much narrowed. However, you're starting to see courts applying common law standards, which invoke the guiding principles. You see this in Canada, you see it in South Africa, you see it elsewhere. Some have said that the guiding principles are simply a law in waiting. Simply, it's a norm that is waiting to become a law, just like law is often called a lagging indicator of ethics. So you're starting to see some very creative use of the common law, not only negligence theories, but conversion theories as well. Lawyers are very creative, and also in this day and age, where you have immediate connection, you're starting to see between different communities. You're seeing NGOs in Laos, big law firms in New York acting on a pro bono basis, being able to get together and file a lawsuit in the High Court in London very quickly and moving and collaborating together. So the liability situation for companies, notwithstanding what's happened in the Alien Tort Statute, is still a problem.
Are we ready to conclude? Or should we? Okay. I could talk about this for days, but we will have to conclude, although I think that you'll be staying for the rest of the event if people have questions. And thank you so much for sharing your time with us today.
Thank you so much, Mr. Sherman. Let's just make sure that we reconvene, let's say about